It's a pleasure to talk to you.
Same here.
So you've been practicing law for a very long time.
Say around 15 years.
Yes, wonderful. So can you throw some light on the current affair of things in the Indian judiciary system?
Yeah, of course. I can say something about that. See, in my 15 years, what I have seen is in 100 cases that are filed in the court, as I believe, 70% cases are frivolous.
Oh,
And in fact, it could be more also.
okay.
So the difficulty is more with the false cases or frivolous cases that are being filed nowadays. Not nowadays, in fact, it's a very old tradition. And in fact, everyone abuses the law, misuses the law.
Sure.
And recently, we have seen a software engineer committed suicide
Very painful.
in Bengaluru, where what has been learned that 9 cases have been filed against him and his family members. So apart from that, it's not only that women misuses the machinery of law. Every law is vulnerable to misuse. It's not that only women laws are vulnerable. This comes into light because for many reasons. So, in fact, what could be the solution? And I could only answer in the legal way.
Right, yes.
What could be the solution? See, there is a legal expression which is called jurisdictional facts. So, whenever a person comes to the court of law, he has to plead his case.
Right.
And based on that, the other side replies. This is insofar as civil jurisprudence
Yes.
is concerned, because in criminal matters, the accused has a constitutional protection to remain silent. He could not say anything, and all the burden is on the prosecution to prove his guilt beyond reasonable doubt. In civil matters, at least insofar as we talk about domestic violence cases or maintenance cases, divorce cases, Section 498A IPC is a criminal that apart.
Right.
So, if we talk about pleadings, a person comes to the court of law and he has to satisfy the requirements of law so as to claim judgment in his favor.
Sure.
So, in legal expression, this is called cause of action. And if we delineate cause, what is cause of action? See, suppose I ask for I have a property and that property is being taken away unlawfully. So I go to the court of law and say that this is my property, I have a right over that property. So you are required to plead certain facts. These are called jurisdictional facts.
Sure.
And these jurisdictional facts are required to be pleaded unambiguously. So what is otherwise happening now, a very vague pleadings are made about rights. On those vague pleadings, the court issues summons, the parties replies. So once there is the court strictly insists for jurisdictional facts, pleadings of jurisdictional facts. I mean, he must, the person whoever comes to the court of law must very clearly plead his case. What is his case? Because otherwise, I tell you one more thing. Insofar as at least women cases are concerned.
Sure.
See, our husband wife may have disputes,
Right.
but then his parents are also roped in. His brother are also roped in. So what these lawyers do, I must blame lawyers also for, because it's the lawyer's mind which works. They made a sweeping allegations. Respondents. Respondent one is the husband, and the allegation is made against the husband, and but the word is respondent. So there are no separate allegations against the other person. I mean, see, whenever you sought to array any person in the legal proceeding, there has to be separate allegations against him what he has done. Otherwise, how can you rope any person?
Right.
So these are jurisdictional facts for every respondent.
Okay.
Has to be very clearly pleaded in every proceeding. That would expose the person who is filing the frivolous cases, because making a bald allegations, sweeping allegations, blanket allegations, and the court issues summons, notices, and the other party is roped in, has to reply, then
Sure.
all these would be nipped in the bud if the person who comes to the court and is obliged by not only by law, even there are sufficient laws which either otherwise obliged them to make a proper disclosure. But then, what is required is from the courts also that they should scrupulously call upon the person who comes to the court, say you have made allegations against one. What are your allegations against one? Make it very clear.
Sure.
It can't be vague and unambiguous.
Right.
So this would curtail a good amount of litigation, of frivolous litigation. These are called jurisdictional facts. In the sense, jurisdictional means so as these are the minimum facts which must be pleaded so as to court to exercise jurisdiction upon a list. List
Sure.
means litigation.
Sure.
So therefore, these are minimum facts which must be pleaded
Right.
so as to array any person in the litigation.
Right. So,
In the other sense, if we talk about criminal matters, these are called ingredient of offences.
all
Like
right.
cheating, there are
Yeah.
certain ingredients which has been defined in the
Right.
provisions. Similarly, it is everywhere defined insofar as civil matters are concerned. These are defined in specific relief act.
Sure.
So these facts must be very clearly pleaded. If you talk about domestic violence, so what are the requirements to array any person in domestic violence? The requirement of law is pleaded is stated in the domestic violence. So those provisions must be strictly followed by courts and by courts at least.
All right.
Yeah.
So, what can be done for a quicker outcome from the existing framework?
See, insofar as these frivolous cases are concerned, most of the frivolous cases would not go further unless these pleadings are there. So, one thing is there. Secondly, we come to genuine cases, suppose. So, we have a very good now, at least commercial matters, we have a commercial suits.
Okay.
There is a in 2016 Act
Sure.
which provides for a very quicker disposal of matters which are commercial in nature, commercial disputes.
Sure.
That instead of, if we specifically talk about 138 cases, check dishonor cases,
Right.
and in commercial, if it has overtones of commercial dispute, I would suggest not to go for 138 because it's a trial-based litigation, it's
Okay.
a criminal trial.
Sure.
And commercial suit would be a much better option because see what happens, I'll tell you very briefly about how it transpires. The commercial suit. A person files a suit, and the moment the summons are served upon him, he can take out a summary judgment application
Okay.
and ask for immediate judgment, saying that the other side has no defense.
Okay.
It's such a quicker remedy.
Achha.
I mean, there are remedies.
Right,
available.
right. Oh,
Apart from that,
Right.
it's not something new.
yes.
We had a summary suit kind of thing earlier also, and still we have it.
Sure.
But that was only for money matters, money claims.
Okay.
Now we have a commercial suits. It encompasses any dispute, including money claims.
Okay.
So this is insofar as civil matters are concerned, civil suits are concerned, and if it's a commercial dispute, one can definitely go for commercial suits. It's really quicker. Of course, it will not be so quicker as we envisage, but then at least,
Compared to the traditional.
you can immediately ask for judgment.
Oh.
The moment you serve it, of course, you have to satisfy the
Sure,
court on
sure.
your merit
Yeah, yes.
that
Based on
I have a merit and he has no defense. So this is one of the things. Apart from that, there are many other. You can say, as I've given the example of 138.
Right.
Let me elaborate something more.
Sure.
See, 138 is a criminal trial. So it's a trial-based remedy. What happens, so in bulk of the cases we have money matters. I mean, 138 forms a huge chunk of the
Right.
outstanding litigation.
Yes. Yes.
So 130 is so ingrained in our system. Whenever it happens, people rush to 130. But then I usually suggest all my clients not to go for 130 because it's a trial-based remedy. The entire trial closes. Otherwise, for the same remedy, you can find a civil suit, you can find a commercial dispute, commercial suit, and you can definitely get a much earlier judgment in that trial based, because otherwise in commercial suit and other summary suits, it's not immediately a trial based remedy. You can go for judgment immediately after serving, जैसे मैंने आपसे कहा
Right.
summary judgment.
Sure.
Summary suit में भी यही procedure है. Immediately you serve the summons and he is called upon to show his defense, and otherwise
Right.
court is entitled to pass the decree. So it's a very good remedy insofar as money matters are concerned. 138, I mean, should least you can adopt both also. But
Okay,
then
parallelly.
parallelly, because it's a civil remedy and criminal both are
Right,
available.
right,
It's
yeah.
not that you cannot file both.
Right.
But then again, expenses are involved.
Right.
So it's all upon the person
Sure.
whether to go for both or not. But then I would definitely suggest people to go for a civil remedy of
Okay.
filing a suit.
Sure.
Coming to writs,
Right.
you know writs, of course.
Not much.
Okay. See, writ petitions,
Okay.
which are filed in the High Court and Supreme Court,
Right.
under Article 226
Sure.
and 32 of the Supreme Court.
Okay.
So the writs are maintainable mainly against the state, not private dispute. Suppose a dispute with the government,
Right.
municipalities,
Okay.
any
All
state
right.
body.
State to state. Sure.
So what happens? I mean, it's a very wide remedy available to a citizen, and matters are directly filed in the High Court.
Sure.
It is originated. Of course, we have all the laws borrowed from British system.
Right.
So this is also been from the British. I mean, writs are, in fact, it is in the broadest written mandate.
All right.
Mandamus.
Sure.
So, writs is in fact a very summary kind of proceeding. It doesn't contemplate any trial like
Okay.
in the
Right.
suits.
Sure.
It's a civil remedy basically. Like in there are civil writs and criminal writ also. Like we see usually quashing of FIRs.
Sure.
So
Yes.
people go in writ only before High Court, because only High Court has power to quash FIRs.
Right.
The lower judiciary, district judiciary doesn't have the powers. So writ is also a summary proceeding. But what we see usually, in fact, it has been observed by many high courts and Supreme Court also, that even the representations made by people are not being decided by the authorities,
Right.
and then the person has to come to all the way to the High Court. So therefore, there could be a situation where there are many cases being filed and decided outright, where in one or
Sure.
two proceedings, hearings, the matter get over.
Okay.
But what happens, the matter
Right.
doesn't come in the hearing itself.
Right.
So there could be a possibility where the courts could envisage a mechanism where a very limited relief is sought for deciding the representation of the citizen.
Right.
Those matters can be decided in, because there could be
Yeah.
no prejudice
Right.
to the respondents in deciding.
Yes.
So instead of getting disputed on merits of the case in the High Court, it is better to direct the authorities to decide the representation, and if then still the dispute persists, then the matter can be agitated again with the state.
Got
So
it.
insofar as writs are concerned, there could be, the High Courts could
All right.
can devise a mechanism whereby a very limited relief is sort of deciding representation. A separate bench could be constituted
Right,
for
right.
those things.
Okay. All right.